Hello, everybody. This is Attorney Bob Probst of the Probst Law Firm in Winston-Salem, North Carolina. Today is July 8th of 2020, and this is another one of our live Wednesday Facebook conferences where I discuss some aspect of the law that some of you may or may not be interested in. The last 2 weeks, I've come to you from my backyard. This time, as you can see from the background, I'm back in my office in downtown Winston-Salem to discuss this week's broadcast. As I discussed with you last week, this week I had decided to talk about Chapter 7 bankruptcies and how they are filed and the process for filing them and why somebody might want to file them. A Chapter 7 bankruptcy as opposed to some other form of bankruptcy. As a reminder, just to let folks know, the bankruptcy code was written by Congress in an effort to allow ways for people and businesses, but in this case, I'm talking about people, to clear themselves from their financial debt that they're in for whatever reason they become in debt and find the financial freedom and make a new step forward and put the debts that they have in the past behind them. It is designed to give debtors a new start, a fresh start financially so that they can move forward with their lives in not just a financial way, but in a personal way, a family way, a business way. There are many, probably millions of individuals and businesses who have taken or used the bankruptcy laws as they were meant to be used to get a fresh start or a new beginning financially. So remember that if you're listening to this or you're thinking about whether you should file bankruptcy, just remember that it was actually written into the law to give you this opportunity to put your current debts behind you and move on in a fashion that allows you to just have a new beginning and get a new fresh start. Some general information about a Chapter 7 bankruptcy. It is probably the most common form of bankruptcy filed in the United States and in North Carolina for individuals. It is a liquidation of your assets and your debts versus a reorganization of your assets and your debts. So for Chapter 7, what you're trying to do is just get all of your debts forgiven and keep your assets if you can. Whereas in a Chapter 13, you're looking at reorganizing your debts so that you can pay them over a period of time, but pay less than what you actually owe. So Chapter 7, you're just trying to discharge or get rid of all of your debt, not have to repay it. Chapter 13, you're under a reorganization. A Chapter 7 in North Carolina allows you to have forgiven or discharged most consumer debts, most unsecured debts. Those are things like credit card debts, personal loans, medical bills, other types of unsecured bills. And the idea behind it is to allow you to have those debts forgiven or discharged so that you can move forward and not owe any more money on those. The types of debts that can't be discharged typically in a Chapter 7, there are a few. If you decide you need to file a Chapter 7, then you're going to want to talk to the attorney you're working with to see if these apply to you. But generally speaking, you can't discharge child support. If you have a court order ordering you to pay child support, you can't discharge that. Recent tax debts, you usually can't discharge those. Uncle Sam likes to get his cut, so chances are you're not going to be able to discharge that. And student loans, and that's obviously a big one these days because we all know and read everywhere out in the community, everywhere online. It talks about the huge burden of student loan debts to kids coming out of college or have come out of college in the last 5 years. I know some people personally who come out of college or graduate school, $200,000 in student loan debt. And at the present time, that student loan debt is not dischargeable under the bankruptcy code. You may be able to discharge your credit cards, but you're going to be stuck paying that student loan debt. So those are kind of things you want to talk to your attorney about if you have any of those kind of debts. So one question we get all the time is, who is eligible to file a Chapter 7 bankruptcy? Well, it's designed for mostly individuals who meet a certain income level and have certain assets and debt criteria. It is designed for people who have more than, say, 50% of consumer debt as opposed to business debt. So if you've got 60% or 70% of your debt is related to your business, Chapter 7 might not be the way for you to go. But if 50% or more of your debt is consumer type debt, credit cards, medical bills, personal loans, things of that nature, then you're probably going to be eligible if you meet the other criteria. And finally, you can have filed a Chapter 7 bankruptcy in the last 8 years or a Chapter 13 bankruptcy in the last 6 years. So those are the three basic criteria for who can file a Chapter 7 bankruptcy petition. Now, often people ask us when we consult with them, what are the steps for filing a bankruptcy? What's, practically speaking, what happens? How's it done? What's included in it? What do we have to do? And depending on how you look at it, there are anywhere from 5 to 7 or 8 steps that you take in the process from start to finish for a Chapter 7 bankruptcy in North Carolina. What I'm going to talk about today is I've kind of lumped it into 5. I think that covers most of the information and the processes and the steps that people run into in your typical Chapter 7 filing petition. So today I'm really going to break it down into the top 5 steps to be done to file, complete, and be discharged from a Chapter 7 bankruptcy in North Carolina. So what is the first step to filing a Chapter 7 bankruptcy in North Carolina? It's determining if you're eligible. So step number 1 is determining if you're eligible. And again, you go through those things I talked about earlier, but mostly the way that's determined is whether or not you pass what Congress has called a means test. So back in 2005, when Congress changed the laws up a little bit, they put in this means test to limit the number of people who can file a Chapter 7 bankruptcy versus a Chapter 13 or some other type. And what they were trying to do basically was try to make a determination that if you have enough extra income at the end of the month after your bills to pay something towards your debt, like in a Chapter 13, they're going to want you to go to a Chapter 13 and pay something. Whereas, as you recall me saying earlier, in a Chapter 7, you're not going to pay anything towards that debt. It's just going to be forgiven or discharged. So they came up with this means test for people to look at to determine, first of all, whether they're even eligible. So what is the mean test as far as filing bankruptcy, a Chapter 7 bankruptcy? Well, basically what you do, it's a formula, but what you do is you take the average income of the debtor for the 6 months prior to filing. So you look at their past 6 months, you see what their income was, and you take that average, and you compare that to the median income of a household the same size as the debtors in the same location as the debtors. And that median income was decided by Congress. They came up with whatever, for example, the median income for a family of 4 in Forsyth County, North Carolina, what that is. So what you do is you go back again and look at the last 6 months of the debtor's income, and you compare it to that median for the same size household in the same location. So if my debtor has a household of husband, wife, and 3 kids, it's a household of 5. If the debtor's average income for the last 6 months is equal to or less than the median income that Congress decided would apply, then you pass the means test, and you're allowed to go forward with filing a Chapter 7. If your income, your average income for the last 6 months of the debtor is greater than that median income delineated by Congress, then there's still a second way that you can try to become eligible or qualify for a Chapter 7 bankruptcy. It's a little bit more complicated, but basically you look at the expenses that Congress allowed, and that the state allowed, and you try to put them into a worksheet. And when you're done all of that, it may be that you're still eligible to file for a Chapter 7 bankruptcy. So there's two ways really to file, to be eligible to beat the means test for Chapter 7 bankruptcy. Number one, have the debtor's average income for the last 6 months be equal to or less than the median income determined by Congress, or go through the second process of looking at the standardized expenses that Congress allows and see if you qualify that way. So that's the first step for determining whether you should file a Chapter 7. If you can't pass the means test, then you're probably going to be forced to do a Chapter 13 bankruptcy filing. Doesn't mean you can't file, just means you're going to have to file under a different chapter. And we're going to talk about Chapter 13 bankruptcy filings next Wednesday. So if you think that might be you or someone you know, encourage them to tune in at 4 o'clock next Wednesday, and we'll talk about that. The second step to filing a Chapter 7 bankruptcy, the second step to filing a Chapter 7 bankruptcy is for you to get what's called pre-filing bankruptcy counseling. So another thing that Congress did in 2005 was force debtors into taking 2 different financial counseling courses, one before you file and one before your case is dismissed. So the one before you file, you have to take before you actually file your petition. The good news is it's an online course, so you can do it from the privacy of your own home. It runs about $35 to $40 to do. And when you're finished taking that course, which is, again, an online course that you can do in one sitting, you'll get a certificate that says you completed that course. And you'll put that certificate with your petition when you file it to show that you've completed that. So step 2 for filing a Chapter 7 bankruptcy in North Carolina is to do your pre-filing bankruptcy counseling online course. Step 3 for filing a Chapter 7 bankruptcy case in North Carolina is probably the most time-consuming and the most difficult step of all, and that's preparing your petition. That's getting the documents necessary to support the petition that you're going to file. So basically, the Chapter 7 petition is a form that Congress put out that everybody does the same form, but it basically really makes you go through and list all your assets and their values and whose name they're in, all your debts and how much they are, whether they're secured, whether they're unsecured, whether they're loans, whether what your income is. But it's a pretty lengthy package of various forms that you have to complete that lays out all your assets, lays out all your income, and lays out all your debts. And then it's going to ask you to file with it supporting documentation to support the value of those assets or to support those debts as well. Chances are you are allowed to file one yourself if you feel like you can complete the petition yourself, but I would recommend you at least speak to an attorney about it before you do that, because if you do it incorrectly, your petition may be dismissed and your debts may not be discharged or forgiven, which means you're still going to owe the debt. So you really want to make sure you get that right. One of the things you're going to have to do besides list all your assets and list all your debts is list all your creditors. And by list them, I mean the names of the creditors, the address of the creditors, and they have to be accurate addresses, because later in the process, those creditors are going to get notice that you filed a bankruptcy. And then they're going to have certain things they're going to have to do if they want to be involved in it. And so you need to make sure you give the court correct information so that those folks can get notice that you filed bankruptcy. And one of the best ways to do that is really to, and most attorneys will do this and download it into your petition itself, but download your credit report. Your credit report, if nobody's ever looked at one, you should go to freecreditreport.com or one of the other ones you find online. Download your credit report. That credit report will show you every debt that you owe on that report. The amount, what the monthly amount is, who the name of the creditor is, and the address of the creditor. And most lawyers have it built in so that when that's downloaded, all of that information is downloaded into the petition as well, so you don't have to manually put it in. But it's important that you get all your creditors that you think you owe in there. So if you download your credit report and you think you have a creditor that's not on there, we need to manually list them so that they get noticed. Because if they don't get noticed, chances are your debt's not to them is not going to be discharged. So if you have 29 creditors and you forget to notice one of them, then you're only going to get discharged 28 of those creditors. You might still owe the 29th one. And what you do once your petition is ready and you have got all the supporting documentation that you need to file that petition with the bankruptcy court. Filing fee for a Chapter 7 is $335. If you have an attorney, they're going to file it for you, and they're going to do it electronically. There's not really a paper filing any longer. It'll be done electronically from the attorney's office, right? The important thing in getting that petition filed, or one of the most important things about getting that petition filed, is this. If you or someone you know is in a position where they have creditors calling them, we all know that creditors can be very insistent about trying to collect on a debt. They might call you, they might violate some of the rules about when they call you, but they're going to call you several times a day. They're going to send you letters. They're going to send you nasty notices. You may even get sued over one of them. What happens when you file a Chapter 7 petition, there's what's called an automatic stay is entered at that time. And that automatic stay is a legal term that basically tells the creditors, which is another reason why you need to make sure they get notice, but it tells those creditors they can no longer try to collect any money from you directly. So what that does is it stops all collection procedures that are going on at that time. So if they're making phone calls, they're stopped. They can't make them anymore. If they're sending letters or notices, they can't send those directly anymore. If there's a lawsuit that's filed, that lawsuit is stayed. It is stopped. So it can't go forward either without getting some permission from the bankruptcy court. So it's very important for those people who are so far into the debt that they've gotten to the point where they're calling, harassing, being sued. Once you file it, all those things stop, and some of the stress you're feeling or the debtor's feeling may be relieved from that point on, knowing that your creditors can't contact them directly anymore. They're going to have to go through the court or through the attorney. Once a petition is filed, it's assigned to what's called a bankruptcy trustee, which is an attorney that's been appointed by the court to sort of review your petition or the debtor's petition, take a look at the assets, take a look at the debts, take a look at the supporting documentation, and just kind of get a feel for, are there assets that can be gathered that aren't exempt? And I'll talk about exempt assets in a minute. But are there assets that can be taken basically by the bankruptcy trustee and sold so that some of that money can be used to pay any of the creditors, right? So remember, under a Chapter 7, it's more of a liquidation. So it's, are there any assets the trustee can take from you that they can then sell and then use that money to pay some of the debt? North Carolina, like every other state, allows you to exempt certain property from being taken in a bankruptcy. What that means is there's certain property you can say, I'm keeping and you're not allowed to take from me to sell to pay my debts. And that is a form that's completed, and it is specific to certain types of assets, the value of those assets, whether there's equity in those assets. And that's a form you and your attorney are going to want to try to take all of your assets that you have and try to fit them within that exempt status so that they won't be sold to pay any debt, but instead you'll be able to keep them. The exemption form's a little more complicated to be able to go through in this atmosphere, but your attorney will go through with it and they will try to fit as many of your assets into that exempt status so that they can't be taken from you. Oftentimes we get questions that say, people say, I have a car and I want to be able to keep my car, or I have a house that I'm buying and I want to be able to keep my house. Can I still file a Chapter 7? Well, the question is, that depends, but in all likelihood, yes, you can. So remember I said earlier that the goal for Chapter 7 is to discharge all unsecured debts. Well, if you got a car that has a bank loan on it, that's a secured debt, not an unsecured debt. An unsecured debt is one where you don't have any, you haven't put that property up for any collateral for a debt. But when you buy a car and you have a loan with a bank, the bank collateralizes that loan by getting a note that attaches to the car. Same thing with your house. If you're buying a house, your bank gets a mortgage, and that mortgage is collateralized by the house. So I have people who might ask me, well, I want to keep my house and I want to keep my cars. Can I file a Chapter 7 and keep my house and keep my cars? Well, there's a couple issues to go through there. And when you're meeting with an attorney, they'll be able to give you a more concrete answer. But the idea is this. It depends on how much equity you have in each one as to whether or not you'll be able to exempt them from being taken and sold to pay off debt in a Chapter 7. And if you can't, then you might again want to look at a Chapter 13, because you certainly can save it under a Chapter 13. But under a Chapter 7, it's going to depend on how much equity in them to some extent is in them. And as we all know, a lot of times cars, once you buy them and you drive them for a year or two, they're almost upside down from what you owe, what you could sell them for. Houses is a little different. But that's something you're going to want to look into, is what is the equity in it. The other thing you want to make sure, if assuming the equity allows you to keep the house and the cars, you need to make sure you are up to date on your payments for the house and the cars. You will want to be behind on those when you file your petition, because then they won't be exempt. So for example, if you were to come in the office and you say, I'm behind on my car payment, 2 payments, I would tell you before you file, you want to make sure you get those 2 payments paid up, so that when they file, the date we file, you're paid up. Because if you're paid up, you don't owe any back car payments, you don't owe any back mortgage payments. If you're called up and the other requirements are met, you're going to be able to keep those assets. Now, what's likely going to happen with regard to those assets is you're going to be asked by the creditor to what's called a reaffirmation of the debts on those assets. So your loan company, Ford Motor Company, if that's who loaned you the money for your Ford, is going to ask you to reaffirm that debt, which means going to ask you to sign documents again saying, yes, I'm going to continue to pay this debt in the same way that I had been paying. And same thing with your house. Your mortgage lender may ask you to reaffirm that debt. If you reaffirm the debt, then what you need to know about that is, and your attorney will discuss it with you further, is that if you then get behind on payments later, that property is not protected by the bankruptcy you just did, because you reaffirmed it after the bankruptcy. You agreed to pay it after the bankruptcy was filed. So that's something for you to discuss with who's ever helping you file your petition at the time you do it. But those are key things you want to remember if you have houses and cars that you're wanting to keep and you're trying to file a Chapter 7 bankruptcy. So that's the third step for taking filing a Chapter 7 bankruptcy, is getting a petition filed and all of that. The fourth step in a Chapter 7 bankruptcy in North Carolina is what we call the 341 Creditors meeting. So after you file your petition, and after that petition is assigned to a trustee, you're going to get notice that you need to attend a creditors meeting, otherwise known as a 341 meeting. The creditors meeting before COVID was in person, usually in a room in the courthouse. Now they've been doing most of them virtually, and I don't know if they'll continue to do that even after COVID, but it seems like a good idea to me. But in any event, either virtually or in person, you're going to be asked to attend the creditors meeting. The creditors meeting takes about 5 or 10 minutes of your time to do. And what it basically is this: the trustee will be there, you'll be there, your attorney will be there, and creditors can be there if they want. Most of the time, in 90% of the cases, there are no creditors there challenging the petition. And so what will happen is the trustee will just go over some of your basics with your petition with you. They'll ask you questions like, is the petition truthful and accurate to the best of your knowledge? Has anything changed since you filed this petition with regard to your assets or your debts? They might ask you a few other questions, and then They'll ask if there are any creditors there or any questions. And again, 90 to 95% of the time, there's not going to be. And that'll be the end of the creditors meeting for you. Typically 5-10 minutes the most. After the creditors meeting, the fifth step in filing a Chapter 7 bankruptcy is the discharge. So if the trustee accepts your petition as is, doesn't have any questions, doesn't feel like there's anything he needs to get clarification to, doesn't feel like there are assets he's entitled to take to sell to pay some of the debt, if everything's done well and everything's done right, then he's going to accept your petition, and in about 60 to 90 days, you're going to receive a discharge notice. And that's the final step in the filing a Chapter 7 petition, is the discharge notice. And what that means is you're going to get a notice saying all those debts that you listed in your petition are now discharged or forgiven. You no longer owe them. You no longer have to pay anything on them. They're gone. They're wiped out, right? And your case is closed. So there's nothing left to be done. Your case is closed. It's over with. Now you get to move on to put yourself in a position to reestablish your financial credit and to reestablish your financial situation so that you don't get caught in the same situation again, so that you can begin to breathe easier, feel less stress, move forward with your life, make plans with your life, and find that financial freedom that you may have been hoping for years. But until you filed the bankruptcy, we're not in a position to even fathom that you could have another financial life, that you could somehow be from underneath the debt. Now, one thing I did forget to tell you was, I told you there's 2 credit counseling courses you need to take. One was the pre-filing one, that's online. The second one, before your petition can be discharged, before your debts can be forgiven, before your case can be closed, you also have to do another financial credit counseling course that's going to teach you a little bit about how not to get in the same situation in the future, how to use credit wisely, what kind of credit situations to stay away from, that kind of thing. But again, the good news is that's also an online course that you can take from the privacy of your own home. Again, once you take it, you're going to get a certificate. You'll file that with the court. Once that's done, you're eligible for the, if you're otherwise eligible for the discharge will be entered. So that's basically the nuts and bolts of filing a Chapter 7 bankruptcy in North Carolina. There are those 5 steps that I think you should think about when you're deciding whether to do it. 1, do you qualify? Step 1, do you qualify using the means test? Step 2, get your pre-filing credit counseling online and get your certificate downloaded for that. Step 3, meet with your attorney, get your petition ready, get all the supporting documentation ready, file the petition. Step 4, attend your 341 creditors meeting and answer any questions that the bankruptcy trustee may have. And step 5, receive your discharge and the closing of your case with the bankruptcy court. That's it. Now, there are, as in any area of the law, there are nuances that I wasn't able to go into today. But I hope this information at least gave you a basic overview so that if you're in this situation or you know someone who's in this situation, a friend, a family member, or whatever, please feel free to share this video with them. Feel free to have them come to the Probst Law Firm Facebook page and watch this video of their own. It'll also be loaded up on our YouTube page and on our website, so they can go to that and watch it. But hopefully it just gave you the basic ins and outs of what a Chapter 7 bankruptcy in North Carolina is, how to file one, what the steps are, and then, how long it takes to start to finish to do. If you have any questions, please feel free to send me an email at bob@probstlawfirm.com. Go to our website, take a look at that, probstlawfirm.com. Send me a message on Facebook, and let me know whatever your questions are. I'll be happy to try to answer them. Next Wednesday at 4 o'clock, we'll talk about Chapter 13 and the basics of Chapter 13 and how that works. And then, as usual, I'm open to any kind of discussion y'all want to have in the future in any area of law that you want to hear about. Thanks again for listening. Everybody stay safe, be safe, peace. Thank you.